Good afternoon. Maybe the first thing I need to two things I need to mention essentially is one, I'm actually not an animal lawyer, I'm an environmental lawyer with a keen interest in some aspects related to environmental law and the sort of the reconciliation between animal welfare issues and environmental law. And the second thing is I've changed my title. Because when I submitted my abstract, I've not given it sufficient thought at that stage. So it's intrinsic interest and welfare-centric dignity towards wildlife rights and international law. And the third aspect I need to make mention of is the fact that this is a work in progress. So I would encourage, welcome any comments that you have, honest comments concerning the piece for the paper. So, introduction. Very briefly, this looks, let me just make sure this is yes, I just want to make sure that I've given you the correct, oh yeah, thanks. Two approaches, we've discussed two brief approaches to protection of animals that we've discussed, the distinction between animal rights and animal welfare. I'm not going to deal with that, we've done that. My topic relates to the question whether there's any possibility to allocate human rights at the international level for wildlife due to the vulnerability. It relates to a proposition or proposal made by Ann Peters in a previous publication of her where she actually advocated the allocation of rights on the international level due to the global nature of the problem. And it's based on that argument of vulnerability. Now the questions in terms of wildlife, we also see vulnerability due to anthropogenic threats. We are aware of deforestation and climate change. We discussed that yesterday concerning the issues of climate change and consequence of climate change and wildlife. On the domestic level, we have also discussed, the speaker that spoke before me provided a very comprehensive register of domestic case law where there's already an awarding of rights at the domestic level. Not always human rights, but different sorts of rights. And also in relation to wildlife, the caged bird case is an example of that. So there's certain movement in this instance, the issue of personhood and rights of primates and so forth. Now obviously, when we talk about the dichotomy between rights and welfare, I'm taking it a step further, well, two steps further. I'm asking, first of all, can we use human rights at international levels, so the international human rights frameworks that relates to the transposition of that structure on the international level to wildlife? And when I say that, immediately my first argument would be, this is preposterous, it's ridiculous, and it's dead in the water. Because essentially, if you refer to, if we step back to the issue of rights, obviously, the mantra has always been, let them be, and you can also see that in the work of Tom Reagan, and it's due to the relational aspect between domestic animals and humans, wild animals and humans, social distance, the proximity issue here. So let them be, that lies as fair sort of approach. And the question that has also been posed is whether that approach is indeed satisfactory. And it's especially in the context of the Anthropocene that we've discussed yesterday, where we've moved from the Holocene to the Anthropocene, whether this approach is still viable due to the dynamics of the situation. But there are also other issues that I've mentioned there that actually induces a very clear analysis of the situation. And we should also consider this in the context of the notion of the emerging international wildlife welfare framework. And when I mentioned that, I mentioned emerging and the scholarly contributions that have taken place in the past few years. Because especially the work that I've done, whenever I've published something on international wildlife welfare, the first point of critique has always been from animal rights theory, exponents, theories of ART exponents, is that obviously this is not as strong as animal rights. There's infringibility when we talk about welfare. So those typical arguments. Now, if you take those three arguments, it's quite clear that there's an imperative to consider awarding rights to wildlife, first of all. But my specific question would be, in terms of vulnerability, whether we can then consider international human or international non-human wildlife rights, so on the international level. And I'll explain why during the presentation, why I've chosen to consider this, first of all, human rights, international human rights, and to wildlife. The structure of the presentation is, I will briefly refer to a proposal, counter-arguments, the role of dignity, which has also been discussed. So I'm not going to deal with any of these issues. The paper is roughly 14,000 words, not pages, sorry. And I'm not able to deal with all those issues. What I do know is the problem with this paper is it's quite broad. It tries to incorporate a number of issues, amalgamate arguments in order to present a view. I'm going to also reflect on the political and legal viability of utilizing human rights for wildlife on an international level, and then conclude with so-called complementary approaches. So very briefly, once again, my perspective, and this is also the subject field that I deal with, I'm very much interested and concerned with international law, especially international environmental law. Now, if we talk about the issue of animal human rights, the first thing is I think there's quite clearly the international environmental or international law structure is quite susceptible to non-human personhood. And that's the first thing, and we can talk about personhood further later. I'm just going to make certain statements which we can deal with during the Q&A session. The extension or the argument for the extension of international human rights to animals, and in this case I'm talking about animals more broadly and I'll cascade down to wildlife, is the fact that we can recognize that certain beings have an intrinsic interest in their own well-being. And I'll explain intrinsic interest further later. But why international human rights? So why am I taking it 2 steps further, allocating it to the international level for wildlife? Is quite clearly that in relation to, if we consider wildlife law, it deals with the international protection of wildlife. But essentially the perspective is obviously natural resources. So wildlife as a reference or is referred to as natural resources. But in this instance, obviously, not dealing merely with resources, but with sentient beings. So the issue here is that those resources, those sentient beings, are located in different jurisdictions. But what we see is, and that's also in terms, for instance, of the common concern of humankind in the Convention on Biological Diversity's preamble, there's a globalization of those resources. Because a dwindling or a reduction in the existence when you have threats or threatened species in one country has an impact on biodiversity from a global perspective. And that's why a few years ago Michael Glennon has actually coined this notion of global environmental resources. So my argument is very similar to Ann Peter's argument that in relation to wildlife we also need international protection, not only in terms of conservation but also welfare, because we're dealing with global environmental sentient beings, and they are also exposed in terms of their vulnerability due to anthropogenic effects in the Anthropocene, such as trapping, hunting, killing, and so forth. But it's especially habitat encroachment which is of concern. So another argument would be in terms of international human rights, and I want to make something very clear. I'm currently conducting a thought experiment which we'll have to assess. So I'm not stating that this is law. I'm not even moving into the leg referenda. I'm, from a theoretical perspective, sketching the probability of this from a conceptual perspective. Human rights, I think, and we've discussed that, I made that remark yesterday as well, there is no need to reinvent the wheel as such. We have human rights, we have rights of nature, we have in harmony with nature concepts, for instance, and these are all bound by strands of sort of the natural rights theory idea. And we can use, and I've referred to core first generation human rights, and I will correct myself to an extent as well. It's not a numerous clauses that I've presented today, because what we see is cultural rights could also be of relevance in terms of wildlife, as recognized by the CMS in the recent COP, when they dealt with the nutcracker chimpanzees and their right to culture. But essentially, first-generation human rights can be utilized to further intrinsic wildlife interests, specifically in terms of life, liberty, and freedom. And there are various advantages to this. I'm not going to deal with that, but obviously transposition of the structure to wildlife could ensure that there's international scrutiny of the treatment of wildlife. And utilization, I'm referring to human rights mechanisms, but obviously like or similar mechanisms, where we have the charter mechanisms, for instance, or convention mechanisms, where there's also no need for standing as such. And that is also an advantage. But there's also the issue of symbolic value that is at play here. So therefore, I think it is an opportune moment to consider these aspects. The counter-arguments. So now that I've sketched why, let me just go back. I've used the proposal of Amy Peters. I went 2 steps further due to the similarity in terms of vulnerability, the issue of the global nature of the problem. And what I've done is I've sketched the possibility and advantages in a very brief manner concerning these issues. What are the counter-arguments? And I'm going to put on my environmentalist hat on. And this is a sort of the typical situation that you will have. This extension of human rights or non-human rights to all wild animals could essentially result in the colonization of nature. So you essentially domesticating the whole planet. And that is a typical argument. It's an argument that has been made by Livingstone, for instance. So you're subjecting or subjudicating, essentially, wild animals to the control of humans. And if you refer back to my initial statement of social distance and proximity, that is the crux of the issue here. Wild animals are deemed to be wild, let them be, let them live out their lives and flourish in nature. We should not colonize nature. That could have been a very valid argument, and it still is to an extent when we talk about predation, which I have a tremendous problem with. And hopefully you'll ask me a question about that. But when we talk about this sort of this colonization of nature in terms of that argument also has a weakness or flaw. And that is that in the age of the Anthropocene, or at least the advent of the Anthropocene, we've already subjugated animals to the destructive forces of human beings as agents of change. And there you can read the thesis of Chopra in terms of the Anthropocene. I don't want to deal with that now. It has already taken place. So once again, we need to view this proposition in terms of the dynamical context that we see. So that's the one issue that we should take cognizance of, but it's not an insurmountable challenge. The second is, obviously, it relates to the first, is that dichotomy, which if you've read Saganoff and so forth, Becker and various environmentalists, you'll see that dichotomy between environmental ethics and animal rights theory. So when I refer to animal rights theory, I'll incorporate, we refer also to welfare. So it's that issue of ecosystems, holism, versus the interests of individual animals. That's a typical problem that you have here. Endangered species being a fantastic example, and the culling of animals. That's another example that we can think of in order to explain the dichotomy. But I also think that is not, and that's sort of the typical argument that you also get when you want to talk about awarding rights to wildlife. That objection would surface essentially. But I also think that it's not insurmountable as such. And we can already see that in animal welfare legislation, which has changed as well. And I will refer to my argument in that regard. And Saskia, I think I don't know if you've dealt with the sort of the relationship between rights and welfare and the changing nature thereof. But you can already see that strict firewall, bifurcation process is not really valid as such. And therefore I think there's a possibility to reconcile those ethics. And it's also necessary. Because yes, we need to recognize holism, and it is important because we live in a biosphere, and a biosphere where organisms interact. We need to take cognizance of that, what I refer to as biological realism. But we also need to understand that this biosphere comprises of individual components that interact. So it's about the recognition and the reconciliation of those ethics And I've previously referred to this as a so-called welfare-centric ethic, where I refer to the work of Cochrane, in this instance, Alistair Cochrane. And I think, although he has actually clearly used his argument in opposition to rights, or not as a basis for rights, I do think that in terms of ethics, if you transpose that idea to ethics, it may be susceptible to accommodate certain wildlife rights, which I'll try to explain further. So, in essence, I think I've just mentioned two challenges, typical challenges, should not be seen as insurmountable. So how should we go about this issue then, this proposal that I've just sketched? So quite clearly, if we refer to intrinsic interests, the preamble of the CBD, as I've mentioned previously, recognizes, amongst other intrinsic value, of biological diversity. It's biological diversity, but not wildlife. That's also important just to take note of that. But the biological diversity in reference to biological resources, which are animals, if we make that, what we can infer from that is quite clearly that there is maybe it can be argued, ornamental recognition of intrinsic value in the CBD. But that's also changing, I think, and I've recently argued for certain changes in this regard. But what we can say is that recognition of intrinsic value points to the moral worth of individual animals. And what we need in order to give effect, so that it's not merely ornamental, that intrinsic value, we need to do something else. And the additional mechanism here is generic protective measures. So quite clearly what we can say in terms of individual animals, there is a necessity to present generic protective measures. So not only conservation, but also welfare. And I don't want to delve into that issue again. Such as the 5 freedoms. But the 5 freedoms, once again, what we need is we need to tailor specific protection for wildlife, and not only species, but also species in terms of wildlife. And it's here where Michael Bowman, in a chapter, in a very extensive chapter, in a book published, I think it was published in 2019, he referred to recognition of dignity as the possibility to create specific protective measures based on the generic protective measures. So the recognition of moral worth requires generic protective measures as an imperative of the CBD, but then dignity is that gateway in order to sort of create specific protection measures. And my understanding of dignity, and we've discussed that, it's a minimum threshold. It's a state or quality of being worthy. The content of dignity, that's the one thing. So there's a certain substantive content, and then rights that are inferred from dignity are tailored to the well-being in terms of the well-being, the interests in the well-being of certain animals in specific cases. So certain species. And it relates to the cognitive, sensory, and emotional life. And here, obviously, the critique could be that I'm using the capacities approach that I think you've referred to, Eva. So it's something we can also discuss. And obviously, determination of the content of the rights, but also that means the linking it to dignity means that there's a need to have recourse to certain scientific fields in order to have an understanding of the substantive dignity. And my understanding of dignity in this sense is it's not animal dignity, it's not human dignity. It is the utilization of a model of human dignity that exists in our anthropocentric law, but we use that and recognize that in terms of scientific perspectives, but also the moral imperative, that we need to create something which is more integrative and which I think is more inclusive. So I consider dignity to be something that is that constitutes the spectrum. You can find human and non-human animals. And here we can also discuss, obviously, on that spectrum, whether we can include non-sentient beings, not the focus of my presentation. And these organisms share a biosphere. So if we go back to the capacities argument, it's not as such a hierarchy that is established. So on the spectrum. It's a spectrum, a horizontal spectrum, which is contextual in terms of recourse to biology and other scientific fields, but also situational in terms of the proximity argument and social distancing. Social distancing, sorry, I'm thinking about COVID. Social distance. It's Freudian slip. I mean, I'm not going to talk about this. I've just referred to 2 examples there. There are countless examples here of glimmers of hope, of, I think, a more inclusive dignity. So what I refer to as integrative dignity or welfare-centric dignity. So in law, and this is obviously on the national plane, not the international plane, but it does provide us with certain lessons. Now, if we use that sort of integrative, welfare-centric dignity on the basis of the need for protective measures, what we then get is we can then infer certain rights. And there are 2 subcategories that I've identified. The phenotype and genotype rights. So genotype, I think, already exists in law. I don't think we can argue about the fact that, CBD, CMS, CITES include provisions concerning extinction. So I think the first and most important right for wildlife is the right, non-human wildlife right, not to become extinct. And I think it's not difficult to make that argument. That relates to the genotype of species. The second is the protection of intrinsic interests, such as a prohibition on cruel, inhuman, and degrading treatment. And dignity also provides that sort of hook that we can use in order to make these arguments. In the paper, I've actually analyzed declarations such as UDAR, for instance, and a few other, the Great Apes Project, which I'll not include here. What I've concluded quite clearly, there is no law on this matter. So my argument doesn't really exist on the international level. It's not even soft law that we're talking about. So it's really stretching the imagination. There's even a sense of pessimism that I experience concerning the possibility of states to agree to this. I'll be quite honest. I don't know whether states will be keen to even include something such as UDAR or to sign such a soft law declaration. And I'm not even talking about hard law. It's an opinion. It's pure speculation. Does that mean I've just wasted your time with my exposition of the theoretical possibility of wildlife rights, which will have no impact and is dead in the waters I've mentioned initially? I don't think so. I don't think there's reason for despair. And you have referred to your work, Saskia, in terms of the issue of simple animal rights and primary rights, because there's a problem, obviously, when we approach these issues, and I would like to go back to my first statement, that even when we talk about animal rights, we can have higher forms of protection through animal welfare legislation in certain instances. So it is possible. So that dichotomy should not be confused with the level of protection offered by an instrument. And therefore, what we see is we have what I refer to as rights-like protection offered by welfare. The problem is on the international level, well, not only on international level, but the domestic level, we don't really have welfare provisions, which are similar to anti-cruelty legislation, for instance, on the domestic level. What we do see on the international level is we have a certain movement and we have so-called derivative animal welfare provisions on the international level. So that vacuum that exists on the national level is, to an extent, there's more movement on the international level. And on the national level, what I've noticed now, for instance, in South Africa is a good example, they've sort of started changing that, but it's due to some international law movements. So what we do see is there's a need to strengthen the normative international wildlife welfare framework. And I've referred to whaling as a good example. I think you've read the publication, it's a very well-known publication of the Martin Chopra concerning the right to an entitlement of life of whales. And that could be an avenue to strengthen simple so rights-like protection and move towards an incremental progression towards something that is more fundamental, less infringible. That's the one avenue. So my proposal is we should not do away with this this idea of utilizing international human rights framework for wildlife because of the clear fit that exists and advantages that exist. But what we should do in the meantime is recognize the importance and value of utilizing this incremental movement based on current welfare provisions and strengthening that as well. So it's not an either or, but it's more a pluralistic approach to this issue. The other possibilities, as I've mentioned, latching onto other developments, rights for nature. The Estrelita case is the best example that I can think of here. Harmony with nature. The Pachamama concept, for instance. So all those concepts also offer avenues, not necessarily at the international level, but at the national level. And the previous speaker has also indicated the implications of these developments on, or potential implications of these developments on international law. The third avenue, once again on the national domestic level, is the issue of constitutional rights and the so-called integrative interpretation of environmental provisions. So a purpose or a philological interpretation of environmental provisions to essentially utilize environmental rights to constitute, to an extent, maybe weaker or simple rights like protection in terms of those environmental rights. So creating weaker animal rights. And the previous speaker has given us a long narrative in this regard. And I think that integrative approach is also very promising. So what we see is, in terms of the complementary approaches that we can use, is it can also strengthen international level through two avenues. The one is transjudicial communication, global community of courts that conduct a dialogue, so it doesn't have very direct bearing on international law, but there's also the argument to be made in terms of the general principles of international law, which I think is maybe also stretching the imagination. It does exist, it can be utilized. So I think, it's quite clear there's an interaction here between both international law and domestic law under the auspices of global law, quite clearly. So the other issue that I just wanted to refer to in terms of the international level when we refer to environmental rights is the recent adoption of the UNHRC resolution in 2020 October of an environmental right, which is obviously not binding as such, but it has a promising effect of being soft law to an extent and serving as an impetus for further development. So we have something on the international plane that we can also work with. I don't know, I hope that I've gone over my time, but I'm allowed to. Okay, so very briefly in summation, I've asked a question based on a proposal made, but in relation to a different issue. And I've indicated the reasons for and advantages for considering this proposal. It is quite clear that from a theoretical legal perspective, I don't think there are any conceptual objections to the proposal. The problem may be, obviously, that we're not there yet. But as I've mentioned, there are various proposals that have been made. The ratifications, for instance, Great Apes Project and so forth. So I think there's a need to clearly give attention to this issue of wildlife rights. And that was also my aim with this paper, to consider the matter, although when I started with it, I just felt it's preposterous to write this even. Hopefully it was not, because then I've wasted 14,000 words. But that was my whole intent, and to see how we can develop this further, at least that scholarship can also develop further in this field. But in the meantime, we do have these complementary approaches that we should not disregard and understand sort of the holistic view of these issues. So in conclusion, I'd just like to mention 4 things. I don't think that recognition of international wildlife rights is an absurd intellectual exercise. But I think that's the next logical progressive step in terms of animal rights theory, but essentially actually in terms of human rights, the progression in terms of vulnerability. It's a completion of the recognition of the welfare-centric dignity in response to the vulnerability of all animals, humans, non-humans, wild, domestic. So it's completing dignity, making it more complete. And I think essentially, and this has been my aim as well, it presents an opportunity, this incremental, integrative approach, to dilute anthropocentrism further in law. It affirms our position as animals. We are animals that share the fate of other animals, and we tend to forget that. We live and we die. It's as simple as that. And I think that understanding of our place in this biosphere, in terms of sharing dignity with other creatures, will also act as a force to dilute anthropocentrism. I think at least to diminish the destructive forms of anthropocentrism. And I'll end with my own quote. I think we're on a journey to enable law to play a meaningful role in the provision of respect, compassion, and protection, irrespective of race, social status, or a classification as species or non-human species. And with that, I'll conclude, and I will take any questions. Thank you.